right, we're going to begin some four-voice practice now at 200 words per minute. So we're reading in 15s. Our attorneys, we have Mr. Vernon for the plaintiff and Mr. Burns for defense. Let's identify.
I am Mr. Vernon for the plaintiff.
I am the witness.
I am the court.
I am attorney for defense, Mr. Burns.
Can you hear what change? 15s.
It's the court for the record. All right, in the matter of People versus Charles Arthur Griffith, this is the time set for the preliminary examination. The defendant is in court with his counsel. Mr. Vernon?
Yes, Your Honor. The people are ready. However, one witness was not served, is not here in reference to one of the counts. He may appear. I know there are efforts now occurring in an attempt to have him here, but I want to alert the court that there may be evidence out of order, and that would be in reference to count 2. Mr. Boyer has not been served, so I want to...
Do you anticipate that you will find him before the conclusion of the preliminary examination? Is that right? Or are you suggesting that it may be that that will be handled as a separate matter?
It may well be a separate matter. I would like to do it, of course, this morning, but I am not sure he will be served and here before the matter is over.
All right.
The people would call as our first witness Mr. Kelly. Mr. Kelly, how are you employed?
I have 2 jobs. I work for Howell and also part-time for 7-Eleven on Everett.
What's the address of the 7-Eleven store on Everett?
I don't know.
Well, would it be 1925 Everett?
Yes, that sounds right.
Were you there on March 22 about 1:40 a.m.?
Yes.
Do you recall what you were doing about that time?
Yes, I was stocking shelves.
Did something unusual happen
Yes.
when you were stocking shelves?
Very unusual. This male person came in wearing a ski mask and carrying a gun and demanded the money from the cash register.
First of all, can you describe the height, weight, build of the person you saw?
Well, he was about 5'10", I would say about 160 pounds.
Can you describe the ski mask that the person was wearing?
It was red and white striped.
What direction were the stripes?
Horizontal.
Was the mask covering the complete face?
Yes. Well, except for the eyes.
Were the eyes single slits or one big opening?
No, single slits.
Now, when this person walked in, were there other customers in the store?
No.
When he walked in, did he approach you before he said this statement about opening up the cash register?
Yes, I was at the end of the aisle, one of the aisles, and he came in through the door and confronted me there.
He approached within a few feet of you, is that right?
About this distance here from you and I.
Say between 8 and 10 feet, is that accurate?
Yes.
Can you describe the weapon the person had with him?
It was a handgun. It looked like a Luger type weapon.
Are you familiar with weapons?
No, I mean, it looked like a kind of a German type Luger to me.
Were there any other people that appeared to be with this person that you saw?
No.
Did he point the weapon at you at any time?
Yes.
After he pointed it at you, is that when he made the statement about opening up the cash drawer?
Yes.
What did you do when he said that?
I almost fainted. I was petrified, but I opened up the register for him.
Now, when you opened it up, was there money in it?
Yes.
Do you know about how much that was in there?
$50, $60 in cash, a few dollars in coins.
Did you give him the money, or did the person reach for it himself?
No, he took it.
Where were you standing when he took the money?
I wasn't standing. I was lying on the floor.
How did you happen to be laying on the floor?
He told me to lay on the floor.
Do you recall what he said to you?
Yes, get down on the floor.
Now, were you actually watching him then when he took the money?
No.
What happened after you were laying on the floor?
He took the money and told me to stay there, and then he left.
How long did it take before you eventually stood up again?
Oh, maybe half a minute probably.
From the time you noticed him leaving the store, was that a half a minute you're talking about, or was it less than that?
No, from the time he left until I got up.
Right. It was half minute?
About a half minute, I would say, yes.
When you stood up again, did you go outside to see if you could see him?
No.
What did you do?
I called. First of all, I called the operator because I was so petrified, and I told her that I had been robbed and to call the police.
Did you eventually go outside to look around?
No.
At any time, did you hear any vehicles speed away or accelerate?
No.
Did you then check the contents of your cash register to see if the money had in fact been taken?
Yes.
Was it gone?
Yes.
Was everything in your box taken?
No, just the paper or currency.
I forgot if I asked you, did you tell the court the color of the mask, if you remember?
Red and white, yes.
Red and white. I know this will sound funny, but I assume no one had permission to come in your store, such as this person did, to take your money, did he?
No.
I don't believe I have any further questions. Thank you.
Mr. Burns?
Thank you, Your Honor. Mr. Kelly, how long had you been in the store before this individual came in?
11 o'clock.
And you stated that at the time you were in the store, when this individual came in, you were in what part of the store?
I was down one of the aisles stocking shelves.
Would this be to the rear of the store, away from the door?
Yes.
Did you observe this individual as he walked into the store?
No.
So then you testified that he came in. Did you hear him come into the store?
Yes, the bell sounded.
How far was he from you when you first saw him?
About between you and I, just about this distance.
He said, did he say anything to you prior to your actually looking at him?
No, I think when I looked at him, when we met is when he started talking.
When you first saw him, was he holding the weapon?
Yes.
What did he have you do?
He had me go over and open up the cash register.
Did you go before him then?
Yes.
Did you have your back to him?
As I passed by him, yes.
How close did you pass by him?
Real close, a couple feet.
A couple feet. Were you looking at him as you passed by?
No.
He had you go over to the cash register, is that correct?
Yes.
At that point, you gave him the money in the cash register?
No, he took the money. All right, we're going to do some different warm-up at 210 words per minute. We have Ms. Chung for plaintiff, Ms. Cruz for defense. Let's identify.
I am Ms. Chung for plaintiff.
I'm the witness.
I am the court.
I am attorney for defense, Ms. Cruz.
Okay, begins with Ms. Chung questioning for the record. Now, did you say that you observed the defendant coming into the apartment through the sliding glass door?
Yes.
Was that sliding glass door open?
No, it was closed.
And how did he come in?
Through the hole in the window.
So he never came through the front door, right?
No.
Thank you. No further questions for this witness?
Thank you, Ms. Chung. Ms. Cruz?
Thank you, Your Honor. Mr. Jackson, how many times have you spoken to Ms. Chung about this case?
5 to 6 times, I guess.
5 to 6 times. And each time you speak to her, you go over what happened on the night of July 5. Is that correct? Or the morning of July 5, is that right?
Yes.
And basically, she has been rehearsing your testimony with you, hasn't she?
No, not really. I mean, I'm just telling it the way it happened.
Well, hasn't she told you, well, this is what I'm going to ask, and this is what defense counsel will ask, and gone over what you're saying, what you're going to say?
She did tell me certain things that you may ask.
That I may ask you?
Yeah.
And then did she ask you, and how are you going to respond to that?
Not that I can recall. The only thing that I really recall towards that is yesterday when, I don't remember his name, the guy that helps her, he came in and asked me a few questions, and he just said whatever she says.
Objection. Motion to strike.
By her, you mean Ms. Chung?
Yes.
That's fine. And the objection is
Narrative.
try to confine yourself to the question.
All right.
So this person, was he one of the ones that's demonstrated here?
Yes.
Was he the one that was actually holding the sword?
Yes.
And he had already talked to you earlier before you testified?
Yes.
And he basically said whatever she says, something to that effect?
Just tell the truth.
But she said something referring to whatever she says. Is that Ms. Chung? Is that right?
No, he was referring to you. Same question you may ask me.
He was telling you questions I may ask you?
Certain things she may ask me about my background or something like that.
What about your background? What may I ask you about your background?
Objection, Your Honor. I think counsel needs to narrow the scope of her question, ambiguous as to everything.
Yes, I agree. Can I see counsel at sidebar? We're in chambers with the reporter. In no way do I want to restrict your rights to cross-examination. However, I do want to make sure that we don't go into the areas that we are not going to impeach him.
Well, Your Honor, if he's going to open the door, he's opening the door, speaking about what the district attorney's office has discussed with him as far as his background. He's bringing it up. I had no idea what he was going to say.
That's because I have not spoken to him regarding those areas. And I think for the record, as it stands now, the only instruction given to him was tell the truth when defense counsel asks you about those things. I don't think there is anything that is questionable. I can agree with the fact that him opening the door allows impeachment on the issue regarding the outstanding open 484 case.
Okay.
Well, I don't need to go into that, but obviously he's gotten some direction from the district attorney on what to say as far as his background. He mentioned it. I did not.
Not from this district attorney.
They're one and the same.
But again, the answer as it stands in the record is to tell the truth, and I don't think that.
Well, I understand that, but counsel is entitled to go into what he was told and whatever may flow from there.
Then I would ask that it be done out of the presence of the jury, since I do not know what, if anything, and it could be highly prejudicial at this point in time. I don't know what counsel may inquire into, especially with regards to the 484, Your Honor.
I'm not going to inquire as to that. I've already told you.
I just want the narrow scope tailored to that, and also if, again, I don't know what he was told.
I think we should find out that outside the presence of the jury, and then,
Well, Your Honor, if he's already opened the door, I have a right to go into it regardless.
but with respect to areas that we have ruled,
I've already said I'm not going to go into the 484.
but he doesn't know that.
I'm not going to ask him about the 484 or what he was told in regard to the 484 unless they were giving directions to the 484. I assumed they were just giving directions.
Can I pose a hypothetical? If counsel were to ask, well, what was it you were told? Well, they told me to tell the truth, and they asked me about this 484, this petty theft, and I told them C, Y, or Z.
The question that currently stands, as I recall, correct me if I'm wrong, what about your background?
What did they tell you I might ask about your background?
It was a very broad question.
I am entitled to go into what he was coached to say, what he was directed to say.
All right, I'm going to excuse the jury. I want to hear the answer outside the presence of the jury, and then we'll take the next step as it comes. All right, the jury has left the courtroom. Ms. Cruz, let's have the last question that you posed to the witness, and then we'll see what his response is. Your answer, sir?
I'm not sure what you want to know.
I guess my question is, may I ask about your background?
Well, I have prior arrests, so he said you may bring that up.
And were you told what to say in response to my asking that?
He said the best you can do is stick to the truth.
And did they go over anything in particular that I may ask as far as your prior arrests?
Nothing really in particular.
All right, thank you. The court will find that the evidence with respect to prior arrests would be prejudicial, outweighing the probative value. The jury will not hear that particular item of evidence and testimony from this witness.
Your Honor, I would object and indicate that it is probative as he is being coached as to what questions to anticipate.
There's no question about that, but on the specific issue of his prior arrest record, that issue I feel is not or should not be heard by the jury. You're certainly entitled to go into the other area that we discussed.
Why can't?
The one you certainly can do.
So I want to ask him about his prior arrest, at least this one.
I think we should be very clear with respect to the language and terminology we use.
There's no question about that. Ms. Cruz, you may ask him about the specific arrest and the specific conviction with respect to that specific crime that you're impeaching, that you wish to impeach him on. But generalities with respect to other arrests.
All right, this is some more from our 200. And our attorneys now, we have Mr. Nix for the people and Mr. LaForce for defense. Go ahead and identify.
I'm Mr. Nix for the people.
I'm the witness.
I am the court.
I am attorney for defense, Mr. LaForce.
14.
Begins with Mr. Nix questioning for the record. The last paragraph, second sentence, right after the words, she demanded him to leave.
Counsel, I might stand up and just point it out to him. Did you see it, sir? Did you see it?
Not yet, not in the last paragraph.
Show him where it is.
The next is when Raymer left the residence, he took with him a .357 Magnum revolver and said that he was going to get even.
Going to get what?
Going to get even.
Thank you. Nothing further.
And I object to that again on the basis that taking a .357 Magnum has nothing to do with the issue on whether or not he was residing there when Rails came over on Thursday morning.
I think the purpose of that question in the mind of the DA was the word left. Doesn't necessarily mean he left for good, that he was moving out, that he moved out. But he walked out of the house, so it goes to the weight.
Okay,
Your objection is overruled. It will stay in. Is that all?
that's all I have.
Of this witness at this time.
Okay, you're excused. Well, do you want him to stick around?
Yes, I'm going to offer an Exhibit 1, which I believe I previously had marked prior to this, and I think this other exhibits are all in.
Now, do you rest your case?
Yes.
All right, it's now noon. And off the record for a minute. We'll see you back at 1:30. Back on the record in People versus Brett Shannon Raymer. Everyone is present, the defendant and counsel. I've had an off-the-record discussion with counsel concerning a previous ruling I had made just before we broke for lunch relative to the admission of a statement to the effect that the mother of the defendant told the witness Tate that my son ran out of here with a gun, angry, saying that he was going to get somebody, or words to that effect.